Right, Ronald Ziegler. Sir, you're charged with aggravated stalking after an injunction. Judge Martin finds set the bond at no bond. I find probable cause. I'm going to honor that. Can we set a hearing? What?
This is not in custody. It's no bond hold for magistrate.
All right. What's the state's recommendation?
State's recommendation is a $25,000 bond.
Do you have any priors?
No, Your Honor, he does not. And the state's requesting level 1 pretrial release.
All right. What's the public defender's response?
Judge, he's on disability, and he has a wife that lives with his mother, the wife that lives with her mother. He can't make a monetary bond because of his limited disability check, so he's going to sit in custody.
Who is
bond is attached.
Who is Linda?
That you give him,
who is Linda Mendola to him?
my former neighbor.
And Your Honor, as you can see from the problem, this is something that's been going on for years. This is from an injunction that was ordered in 2013. And it just appears that from what's being alleged, that Mr. Ziegler is just not, he's not stopping. He will not leave this woman alone.
All right, I'm going to...
Judge, if I can continue?
Sure, go ahead.
I wasn't done. I'm asking that you give him level 2 pretrial release that will make sure that he's in his home, ameliorate the concern of the state, that he's contacting anybody. Level 1 seems a little draconian. He's on disability. Because of that, he's just going to sit in custody, and he's entitled to a reasonable release condition. And the presumption is, since this isn't a dangerous crime, that it be non-monetary unless the state overcomes that presumption, which they haven't submitted evidence.
Anything else? Anything else? All right. I'm going to reduce the bond to $10,000. I'll put him on level 2 pretrial release with the monitor. Should he be released, and he's not to have any contact, direct or indirect. He's not to come within 500 feet of the victim in the case, Ms. Mendoza. Mr. Ziegler, if your lawyer is correct and you're not able to post a bond, may I suggest that you ask the public defender to set the matter for a bond hearing, a bond reduction hearing before Judge Fine. He's a division judge. So I'm
Judge,
only... listen, counsel. Thank you very much. Good luck to you.
Judge,
all right.
Judge, if I can just have 1 second to...
Sure, go ahead. Whatever you want.
Please don't get frustrated at me. I'm trying to advocate on behalf of my client.
Let me interrupt you. Okay, the frustration is that professionalism tells us this: before the court rules, you argue to the court. After the court rules, you argue with the court. I think it's rather common in our criminal division that lawyers do not understand that concept. I heard you out. I heard your argument. I heard the state's argument. I heard your argument. I read the probable cause. I make decisions, okay? My suggestion is if you want to further argue the case, no problem. Take it before Judge Fine. He's a division judge. This is first appearance. This is how we operate, okay?
Right.
So right now the record, look, if you want to argue,
Judge,
if you want to put anything else in
there... to have an opportunity to speak, and all you do is continue and continue and continue. I want to provide the court with additional information. He only gets $700 for his disability, so I'm asking that you take it in light and set it at $7,000 so that he can possibly bond out this month instead of having to wait 2 months for his check to accumulate, rather than just pick an arbitrary number out of the sky at $10,000. So I just want to provide that additional information to you now that I have an opportunity to do that.
Thank you very much. All right, and did you hear what I said though? I used to serve in the criminal division, and my suggestion is that if you want...
I don't want any suggestions, Judge. I know how to practice law. Thank you.
All right. No problem.
Am I done now? Yes, sir.
Mr. Reedy, any comment on that last statement?
No.
I think it speaks for itself. Of course. Take your time.